Allegations of racial profiling, racism, and unfair lending practices have once again threatened the credibility of banks. This comes after Westbank was recently accused of charging its black clients higher interest for vehicle financing compared to their white counterparts, an allegation that the bank vehemently denies. Good evening, my name is Sizwe Mpofu Walsh, and welcome to Unfiltered. Independent financial investigating consultant Emerald Fale claims black people are charged as much as 19% interest rates, while the average for their white counterparts is 11.25%. Over the years, many clients have come forward lambasting discriminatory lending practices that they have faced at the hands of banks misusing their power. Joining us to unpack this important conversation are independent financial investigating consultant Emerald Fale, a victim of this crime, Mr. Mzukisi Ndaga, and Jimmy Kholele from the National Credit Regulator. Please note before our discussion that we did invite the CEO of Westbank, Mr. Ghana Msibi, and they wanted this statement to be made clear. They will not participate in a debate with Mr. Fale. The bank will only engage Mr. Fale through formal channels to conclusively deal with the allegations he has leveled against the bank. And so tonight we ask, are banks racist? Mr. Ndaga, could we begin with you? You've been engaged in a protracted legal battle with the banking sector around a personal experience relating to a car loan. Could you briefly summarize the story that you've been involved in?
Yes, thank you. I think the first thing I should say, this occurred in November of 2004. It is effectively 20 years now. I just joined government as a senior manager, and I was induced into this vehicle sale contract. What one then discovered in the final analysis was that it was a fraudulent vehicle sale contract. What we need to understand is that when you purchase a vehicle directly from a dealership and say you've got 100,000 and you sign it off, you are buying that vehicle directly from that dealer. But should a financer be involved, you are buying that vehicle from that financer. In other words, the dealership are agents of the bank. In summary, what happened to me, I was induced into a sale, only to find the net effect of what happened is the paperwork that was processed, unbeknown to me, categorized the vehicle as a brand new car, whereas it was a used vehicle that had done close to 7,000 kilometers. That's the first thing. Secondly, there were fictitious extras, in other words, that do not exist. We will know extras to be tow bars, cruise control, and so forth that you, as a consumer, you request, and they're then added. I had not requested anything, but I was charged an amount of 35,000 fictitious to inflate the price of that vehicle. Thirdly, most significantly, I think aligned to what is now in the public domain, is that I qualified by virtue of being a senior manager in government. There was a Westbank senior manager scheme for all directors upwards. I qualified for a formula that was prime minus 2 automatically, which was then 11 prime, and I qualified for 9% finance charges. What was loaded on my contract was 15.25 fixed. I ended up paying an installment of 8,000 monthly, excluding insurance, for a used Nissan X-Trail 20 years ago. Just to conclude this point, in 2023, Dadnis Nissan was advertising that you could go in and get a brand new Nissan X-Trail at 5,200 without even a deposit or a trade-in. In my initial, I even had a trade-in.
And what do you think were the reasons for this alleged fraud on your part? Why do you think that you were overcharged, that the rates were higher than they should have been per legislation?
What has come to the fore in my journey was that firstly, the increase of these fictitious extras. Of course, if the price is higher, then the commission will be proportionate to that. But more significantly, I was told by a tax consultant this, that the commission that they receive is proportionate to the interest rate that they charge. So that is the incentive.
Right.
I have not said probably the most fundamental thing. There was no valid offer to purchase. I'd never even seen a document. I've never seen such a document. I do have it now. There's no signature of mine offering to signing as a purchaser, making this offer. Then the dealer principal signs below me, accepting an offer that has not been made. That's probably the most fundamental element of this. I'll tell you why. Banks do not even enter the process because the fundamental base document is an offer to purchase. So if there's no valid offer to purchase where it can be demonstrated that there was a meeting of minds, then the bank does not even come in. Interestingly, in my particular instance, the whole thing was processed, there was a deal, and yet there's not even a signature on the offer to purchase, let alone a signature trading in the other vehicle. So it's clear for me that there was collusion, and of course, the banks stood to gain in the region of at least 100,000 more than they would have if this was done properly.
Now, you have taken this matter to court, and as I understand the legal state of play, although you have applied for leave to appeal to the highest court in the land at this point, the Constitutional Court, you've been unsuccessful largely due to a technicality, as I understand it, around prescription and the fact that in layman's terms, that debt was long ago and has therefore expired, and it's hard for you to recover it. Where to from here with your legal battle, and are you hopeful that the Constitutional Court will entertain this application for leave to appeal?
I am very, very hopeful, given the constitutional violations that have occurred over time. But I just need to go back to state that the bank at no point throughout this 20-year ordeal have disputed substantively or even offered an alternative truth, so to speak. They just came to court and said it is prescribed. And one other person, a legal person, said to me, wherever have you heard a criminal act prescribe? Fraud is a criminal act. And so it's been that kind of process. They've been relying on a technicality on the issue. And I've gone from Grahamstown through the SCA, and I'm now before the Constitutional Court. What is probably vital at the Constitutional Court, like what we are asking for, we approached the court for a declaratory order when we discovered the fraud, for a declaratory order to set aside the contract as tainted with fraud and therefore void ab initio. That's what we approached the court for. Secondly, we approached the court, same order, for a confirmation of the cancellation of the agreement for the same reasons. So you then wonder at which point does then a court of law arrive at discussing prescription? A la Makate judgment. There's already a Constitutional Court judgment. That was the same scenario. Makate pursued declaratory order to compel Vodacom to compel them to negotiate in good faith. Vodacom pleaded prescription. There's a Constitutional Court unanimous decision, as you probably know, that a declaratory order does not constitute a debt, and therefore it cannot prescribe. Very clear position. Secondly, the special plea of hearing. I was in court and I gave evidence. Because also, the prescription, I think it's 12.3, it indicates that I, as the applicant, would have had to acquire true knowledge that gives rise to the cause of action.
Right.
So I gave that evidence in court.
And you are hopeful of a successful outcome?
No, very, very much. Very, very much.
Let's bring in Mr. Van Zyl here, because of course to hear your story and the lengths to which you have gone is really important. Mr. Van Zyl, you've been involved in a string of cases relating to banks and alleged discrimination for many, many years now. It may approach decades. To what extent is this story that we hear from Mr. Ndacha, in your view, representative of a deeper trend of discrimination in the banking sector, particularly related to racial discrimination? And we'll just get your preliminary thoughts, and then after the break we'll unpack them in more detail.
In my opinion, there is a dealer involved here, which makes it very, very difficult to give an opinion. If the matter is criminal, a criminal matter only gets prescribed after 20 years, as my mind served me correctly. And I think he must take that sort of line, as they are pleading prescription on 3 years. It's not 3 years, it's 20 years.
And what about the broader question, outside of this particular case, of racial discrimination to which you have been involved?
Well, the fact of the matter is that it's difficult for me to comment on that because I don't have any documentational proof in front of me.
Sorry, Mr. Van Zyl, what I mean is...
Very difficult to say.
What I mean is this...
Based on the race, in his case, it's very difficult
Mr. Van Zyl, of course, and I'm not asking you about his case. I'm asking you about the wider cases that you've been involved in and the extent to which you believe that allegations of racial discrimination within the banking sector more generally are appropriate.
Okay, let's take Westbank, and I'm going to go back to 2019. A whistleblower phoned me, who was a manager at Westbank, and he informed me that black people are paying a much higher interest rate than white people. I then posted on Twitter that all people, white or black, who's got a contract with Westbank must please forward me their contracts. I received 160 black clients' contracts and 52 white ones. And from that, I could, in analysis of that, I could see where an actuary actually assisted me. I could see that black people are paying, some are paying up to 19%, and white people are paying up to 11.2%. That is about the blacks paying prime plus 9 and whites paying 1.25 above prime. I then was invited on various radio stations for an interview, and Westbank, as in this program tonight, declined that invitation. But they later posted on social media that interest rates are determined by 2 factors. Firstly, affordability, and second, creditworthiness. Now, let's look at affordability. The law is very clear that the installment of a motor vehicle finance loan cannot exceed 30% of your salary. So in other words, everybody that's got a motor loan account can afford it. Let's go to creditworthiness. We all know that if you've got a slightest negative on your credit record, you will not get a motor vehicle finance loan or any other credit loans or something like that. Now, that means that everybody in South Africa that's got a motor vehicle finance loan can afford it, and they are creditworthy.
Right.
Now, this is the question. This is the question that I put to Mr. Masibi the CEO of Westbank yesterday in an email.
And we'll go to a break after this question and come back to it. Please tell us the question so we can go to the break.
The question that I asked him, the question that I asked him, if everybody that's got a motor vehicle loan account can afford it and is credit worthy, why is some people paying 19% and others are paying 11%, and those who pay the 19% happens to be black?
So let me try and understand this, Mr. Van Zyl. Because, of course, the banks have really pushed back very strongly against your suggestions, and as you've seen, they've even refused to join this platform because you are here. Westbank particularly. Are you satisfied that, given all the other variables that could be at play here, I'm sure these banks have very complex models on which they base their loan agreements, one would imagine, that none of these other variables explain the kind of differences that you are seeing, and that this can be causally linked to race?
Well, as I said that I did not post that on social media. Westbank posted it. And now a second whistleblower came out 2 weeks ago who worked at Westbank in the IT department, and he worked there. He provided me with his appointment letter. And he said that when a loan goes through the criteria of being approved,
No problem, Mr. Van Zyl. I think this is an opportune time for us to take our break, as we said. Let's hope that's one of your clients calling you and not a bank. We'll be back after this break for the remainder of our conversation. The allegations of racial profiling and discrimination in banking loans have been swirling around South Africa's public discourse for many a long year, and they've recently resurfaced around questions relating to Westbank vehicle financing loans and whether black clients are charged a higher rate than other races, particularly white clients, purely because of their race. And we're trying to get to the bottom of these allegations, how true they are, and what the evidence for these claims are. We did invite Westbank to join us, but they declined the offer. And we're also speaking to a guest, Mr. Ndacha, who has been through a protracted court battle over these questions of the treatment of consumers by banks, especially when they're trying to apply for a car loan. Mr. Ndacha, I wonder how you, before we come back to Mr. Van Zyl, how you respond to the broader question outside your case of whether there is an element of racial discrimination in the way that banks are treating South African customers.
Well, what I will say from a lived experience perspective, the three individuals who were involved in this whole shenanigan at the dealership level all happen to be white, and in fact, as a result, I believe it's one of those issues that became contentious for the bank to resolve my issue, because you're dealing with three white officials at the dealership who happen to have been involved in this unsavory action. I'm saying that, why I'm saying that convincingly is because I wrote a letter. Within 11 months, this thing had happened. I wasn't aware it was fraud then, I must admit. I wrote about this horrendous installment that I'm paying. And then I was offered by the bank that they can reload the account. Reload meant I've already paid 12 installments, then they're going to take that and refinance it and add another year and then lower it to 13%, which in the total scheme of things, I'll be paying even much more. Then lawyers will tell you that is against the law. Section, I think it's 92 of the National Credit Act. Maybe that's where I should have started. What has happened to me, the bank has contravened the law. It's not about if and but. They've contravened the law. You are not to subject the consumer, you're not supposed to deceive the consumer, not to subject the consumer to fraudulent conduct. In another instance, a dual discounts case versus West Bank, something similar happened in KZN to what happened to me, misrepresentation of the status of the vehicle as well as the price. The bank invoked, I just want to share this with also Ms. Van Zyl. There is a master agreement between a bank and a dealership. They are not buddies. There's a master agreement. It's specified there that the dealer cannot sell or vouch a vehicle outside of the ordinary price of that vehicle. It's part of a standard agreement. They cannot misrepresent. Then, should they do so, the bank is in a position to invoke the master agreement and have recourse against the dealer. It's there, it's a case that's decided. So the question becomes, why did this not happen in my case if you are saying it was the dealership agents that were the problem? You know, let me answer that question directly. I am convinced as I sit here. I believe Mr. Van Zyl is not making up what he's saying. The majority of people that are at the receiving end of this discrimination are black people by virtue. Secondly, I had people who were looking for me when General Lomisa intervened and got hold of me. It's in part of the documents at the Constitutional Court. There are 33 signatures of people who were dealt similarly to me in the last 5 or 6 years. You see, so, and a good number were black people, horrendous things.
Right.
Yeah.
And of course, these are very worrying and serious questions. Mr. Van Zyl, could I come to you though, because it is important that the allegations that you made, you know, are tested, and as far as I understand, you did take a similar matter to court, which was ultimately unsuccessful. And can you comment on that? Because I believe that the matter that went to the High Court around 2013 or so, in that matter, FNB ultimately prevailed, did they not?
I'm so glad that you asked me that question. I summoned FNB on racial discrimination, charging black people a higher interest rate in 2013. That is correct. What happened in the court matter is the first day I was poisoned with arsenal and I landed up in intensive care and I had to return to Cape Town for emergency operation. Now what happened then, because I was not available to support my legal team, that they convinced the court that their interest rates were not linked to prime and they could charge any interest rate they could feel fit for. That is against the Usury Act in the first place. Then the court accepted there, because one of the guys that testified was Mr. Davi Botha, who used to be a director and responsible for mortgage loans. Now it transpired in December 2022 that a document was leaked to me, and in that document it was the 1989 financial annual report, where the CEO said in his oorsig in the financial report that their interest rate was historically linked to prime. So they lied under oath. I've laid charges of perjury against Mr. Darby Botha and also the other person that testified, Mr. Marius Murray.
But I believe the court also went as far as issuing a cost order against you.
They did give a. Now this is where it comes in. Let me just explain here. When the dispute about racial discrimination started, FNB said on carte blanche, on their media, and in the media, that they will pay my cost to testify this in a court of law. I lost it because they lied under oath. Now, the fact of the matter is, they summoned me for 3.4 million rand for their legal cost, which I could not afford. I accepted their offer that they will pay my legal cost and their legal cost, and they sequestrated my estate to recover that after they said to me that they will pay my cost. And I've got all the evidence. I am now pursuing against FNB for damages, and I will summons them in April this year.
Why did the court give that sequestration order if there was an agreement between you and the bank on the legal fees? Because it would seem very unfair for the court to do that. Why do you think that order, again, after the FNB went against you? And to be fair, the banks have really gone for you on this. They've really,
for sure.
Yeah. I mean, to go for your estate, let alone to win the case is a very uncompromising strategy. Let's put it that way. But why do you think the courts have sided with the banks? Because presumably they would have looked at the evidence and come up with an impartial decision.
Well, the fact of the matter is, I am not very favorable with the legal judges in this country because of that action. That is point number one. And number two, all the truth will come out in my case against them when I summons them for damages in April. But what I wanted to say here, it now transpired that they lied under oath. I wrote a letter to Mr. Alan Pullinger, the CEO of First Rand, where I explained and attached all documentation to prove that they lied under oath. Mr. Pullinger, up till today, refused to acknowledge receipt of that letter. I sent that letter via postlet to be delivered at his head office personally and present me with the evidence that it has been delivered.
And with all the contracts that have been sent to you over time, to come back to our earlier conversation, with these recent allegations that have emerged from what you describe as a whistleblower, are you again convinced that there is evidence of racial discrimination in banking and loan practice?
Absolutely, there's no dispute about it. Mr. Mabisi, the CEO of First Rand, said in the media, there's no proof of this. That's what he said. And in my email yesterday to him, and I emailed a copy of that letter to you people, I presented him with 6 contracts, 3 whites and 3 blacks. The blacks are all paying prime plus 7-8%, and the whites are paying prime plus 1.25%. I presented him with that information.
And in terms of Westbank, you believe in terms of these vehicle loan contracts, because a lot of your work before has been on home loans, that there's a pattern across the different sectors of these loan offerings?
Absolutely, I do agree full-heartedly that FNB and Westbank, who's part of First Rand, are discriminating against black people with higher interest rate. Let's look at home loans, just for, if I may. Home loans, they say it's because of a risk factor. That is not so. Most of the black people in townships, when they got loans, they were government employees. They received a subsidiary from the government. Their monthly installments went off directly off their salary. Now, the question I want to ask you, where is the risk? It's less risk than whites, but still they are discriminating against it. And the whole way, or the whole reason for discrimination is profitability. It all comes around profitability.
Right, let's leave it at that for now, and we'll come back to delve deeper into some of the observations from our guests. We're talking about racism in South Africa's banking sector. There have been allegations that particularly banking loans are being used to target black customers in ways that are different to how they target white customers. And there's a suggestion that there's a racial disparity in banking loans. We're exploring those allegations and testing their veracity. Stick with us. Welcome back to Unfiltered. Is there racial discrimination in the offering of bank loans to South Africans of different races? That's our conversation this evening. We did invite the National Credit Regulator, who agreed to join us, but unfortunately we seem to be having connectivity issues. And we also invited Westbank, who's been at the center of these allegations, and they declined to join us. But this evening we're speaking to Emerald van Zyl, an independent investigator who's made many allegations about racial discrimination. Mr. Ndacha, as well, we've been exploring your story where you've been fighting a vehicle loan agreement for over a decade now.
2 decades.
2 decades, yeah. My goodness, and that's now before the Constitutional Court. Yeah. One of the key questions here, which is really at the center of so much of this debate, is the power dynamics between an individual consumer who probably doesn't understand, the legal jargon in any contract. I might add, most lawyers probably don't either. And a massive financial institution which has, obviously this view of the whole market. Talk to us about how that power dynamic has played itself out in your case.
Goodness, you read my mind there. It's massive. I have written a book, A Quest for Justice, and I basically chronicled my lived experience. I need to highlight that that manuscript was read and validated by none other than retired Constitutional Court Justice Edwin Cameron. He's on the cover. At the back of this book, there's a quote from the NDPP advocate Batoi, because I wrote until that level. I'm going to come to that point now. And it says there, Westbank and or its employees breached the contract in the form of misrepresentations and also acted in violation of various statutes, as alluded to in your reports. That's a letter from the NDPP currently. Coming to the power dynamic, there's a weird conclusion to the same letter that says that because of the nature of the contract, the applicable legislation does not invoke criminality, and yet it does. The act is very clear. If you are violating the purpose of that act, whether you're a credit grantor and so forth, you may be liable for conviction and a sentence. That's not civil language. You've asked a very powerful question. My belief, the inclination for the banks to do and to act with impunity is precisely what you just said, the power dynamic. Firstly, litigation. I don't know the percent of people who can actually access courts. I'm going to quote something I said in the book. When I saw, they are well aware that I don't have the resources, let alone the influence. So they strung me along on this issue. And what ultimately happened is For instance, I was just telling you that I gave evidence in court. That evidence I gave in court, the court upheld the special plea of prescription. 2 days later, it's upheld. I was the only one who gave evidence. That evidence was not rebutted. When we filed an application for leave to appeal, 9 very solid grounds, the evidence I gave in court disappeared. It's there from the beginning of the day until the end of the afternoon. It is there. The part that is missing is when Daha was speaking in a court of law. Hence, our second angle at the Constitutional Court is my Section 34 rights. Is my Section 34 rights. This thing of a power dynamic, a number of things have happened, I have to say that, in the courts of law, where you are now wondering what's happening here. General Lumisa intervened, and we ended up at the head office of West Bank. I met Mr. Chris de Kock, the one who just left the position. I was with him with 2 other officials, of General Lumisa and Mr. Eric Mabuza. I narrated this story that is also in this book. The CEO of West Bank said, if it's true what you're saying, and it's accurate, then I must sympathize with you, because you'll have been done a grave injustice.
Indeed. Mr. Van Zyl, what do you make of this deeper question? I'm sure in many of the contracts that you've looked at, you know, this power dynamic between a massive financial institution and a single individual consumer comes into play. What are your views on the way that this power dynamic is working in terms of your allegations of racial discrimination?
Well, the fact of the matter is that, you know, a lot of people, black people, white people, don't read their contract. They basically just sign for it. And that is a main problem, because a lot of people sign the contract and they got a balloon payment, and at the end of everything, they didn't know that there was a balloon payment. So the people don't read their contracts. I hope I answered that question.
No, absolutely. But you know, what's interesting to me is what is in those contracts. And you know, I have looked at a few loan contracts in preparation for this, ones that I could find, and it is interesting to me that in some of them one does have to declare one's race, and it just seems strange to me that you know, still today, what is that box for when it comes to a loan? We're not talking about black economic empowerment here, where you can understand the need to self-identify with race. Why are banks still putting race on these forms, or loan originators still putting race on these forms and asking people to declare their race?
Well, I can guarantee you that I went thoroughly through West Bank's contract. There's no place where they ask you for your race. But they use what this whistleblower that worked in the IT department said, is they use acquisition. That means they use the assistance of a third party. And when a contract goes through certain departments for approval, for instance, ITC and so on, the final department that it goes to before it's approved, the race of the client must be put on that docket.
And what, you know, to the extent that the race is placed on the docket, and whether it's explicit in the form or implicit in the process, and I think we have evidence of both in the country, do you think that there is an intention here to be racist, basically, to kind of deprive black people, in your allegations, of the benefits of cheaper loans? Or is this an attempt to profiteer? In other words, I'm trying to understand how deep this crime goes in terms of the intention. Is it just a pure racist attempt to subjugate black people and privilege white people? Or is there some kind of economic motive that you see, or is it both? What do you think, why, if they are, do you allege that banks are doing this in the first place?
Well, as I said previously, the whole criteria for discrimination is profitability. There's no question or no arguments about that. It's profitability. And why must two whistleblowers come out and tell me that Westbank is charging their black people a higher interest rate? And I've got 160 contracts. And I've given to Mr. Masibi, I've given him contracts and asked him to please respond and tell me why are the black people paying prime plus 6.7 and whites are paying 1.25 above prime. And I tell you now, I give you a guarantee, he will not answer me. That is the reason why he did not want to attend this meeting this afternoon or this evening.
We're in conversation with our panelists this evening about these allegations that have been in South Africa's public discourse for a long time. Are banking loans racially profiling black South Africans, systematically disadvantaging them? And if so, why? We're exploring the veracity of some of the allegations that have been made, as well as exploring the stories of some South Africans who have been in the courts with banks over potentially fraudulent or allegedly fraudulent contracts. When we come back, we're going to look at the way forward, some of the deeper policy questions that lie at the base of this debate, and we'll also encourage some of your views. Stick with us. Welcome back to Unfiltered. This evening we're delving into the question, are banks racist? Following allegations that banking loans are following patterns of racial discrimination. Mr. Fale, can I come back to you? Because as we conclude this conversation, there are some deeper questions just about the power of banks and the apparent unaccountability of banks and the difficulty of regulating banks. So in addition to these allegations of racial discrimination, there have recently been a lot of conversations about what's increasingly called debanking, where banks are just able to effectively cancel the bank accounts of people without necessarily, a proper process. Certainly not a public process. What do you make of the regulatory environment, and why, in your view, have regulators not been able to constrain banks in the way that you, I suppose, believe they should?
Well, I can give you a good example. In my presentation in front of the Human Rights Commission on the 7th of November 2007 on evictions of blacks and they're losing their homes, my opening statement was as follows. I said, Mr. Chairman, consumer protection in South Africa has collapsed, totally collapsed. And I got a standing ovation from all the people that were present. That is the main concern, because if you refer discrimination to the banking ombudsman, the banking ombudsman is only handling single complaints. You can't do it in a group. And if you refer it to the National Credit Regulator, and I'll see he was going to take part here, I believe that the National Credit Regulator is covering everything up. That is my personal opinion.
Mr. Ndacha, Mr. Fale paints a picture of an inability of the average consumer to really hold banks accountable. Do you think that there's an accountability vacuum? And what kind of accountability have you been able to see in this 2-decade-long journey?
Thank you. the vacuum is huge. I have been virtually everywhere. Let's talk about the pillars of our democracy, a constitutional democracy at that. The state. The NPA investigated this. In 2015, it was found a decision to prosecute was taken. I'll leave it at that. A decision was taken to prosecute. It was. And then one of the prosecutors in East London was complained that, why are you including the bank? And the investigator said, but those are the people who are benefiting the most out of this. Why should they be excluded? My case died. I'm starting there. Then, when I say I've been everywhere, I just want to echo what Mr. Fale said. National Credit Regulator, I spoke to the CEO, I wrote and so forth. People basically shiver when you mention the bank. A bank in an African context, allow me to say it, is a foreign concept. You're talking about black people that are literate, semi-literate and so forth. It still represents the old order. Things that have happened to me, they were going out of their way, they couldn't understand, why are you not intimidated? Let's then go to Parliament. I spoke to representatives of the major political parties in this country. General Lumisa is the one who actually took a position and confronted. So the rest quietly disappeared into the horizon. I mean, we're going graphic now. The third pillar is the judiciary. I've got 3 judgments in my, rather against me, that made no sense at all. Okay, that's a subjective view, but it's my view all the same. In all those judgments, there were white judges involved. I've got decisions in my favor, same case. Black judges too, the decision is in my favor. So I'm bringing that race dynamic very clearly. I have had a registrar of a high court speaking to me on the phone. I was pursuing, why is my evidence missing? She said, why don't you let this thing go? The registrar said, why don't you let this thing go? And also another white attorney in Grahamstown called me all the way and then said to me, if I were you, I would have long given up on this thing. So the race dynamic is very real. And I'm going to say the last thing. So that's why I'm very curious, the apex court that looks after our inherent constitutional rights to be. I'm very interested to see, because the other point I've not raised, fraud unravels all. And those courts that have since looked at this thing were supposed to have done so in the prism, within the prism of Section 39(2), which none of them did. They looked at fraud, this is my view, and they looked at race, and they said a lesson to be learned. My parting shot, a parliamentarian posed the question to the CEO, Mr. de Kock, because he also saw that, look for what it's worth. So in this man's papers, there was a 10 million claim at some point. Why don't you offer him 50% to settle this thing? The answer was clear from the mouthpiece of West Bank CEO. We are resisting Mr. Ndacha's matter because it will culminate in a precedent. In fact, it will open floodgates. So the interpretation I got was that we've done this to many, many people, but we've never had somebody resist and persevere to the extent that he has done.
Well, Mr. Ndacha, Mr. Van Zyl, I'd like to thank you very much for your time this evening and for sharing your various perspectives. Before we go, let's look at what you've been saying on social media. We have Jack who says, how can the SA banks be racist when they have co-opted black politicians onto their boards? Tongue-in-cheek, of course, there's also the NCR. They're supposed to be proactive on these matters. Banks are powerful, though. we can screw anyone the way they wish and justify it. One further view from social media is Te, who says, I am so shocked by allegations that FNB Westbank are so racist. I have bought 3 vehicles via Westbank and my bond was funded by FNB for the past 18 years. I'm so angry. Needless to say, as I mentioned throughout the show, Westbank has categorically denied and vehemently denies the allegations made, and we did invite them. They declined to join us this evening. But we've certainly had food for thought on allegations of racial discrimination in loans in South Africa's banking sector. Let's continue this conversation on social media. Thanks for joining us, and have a good evening.